Welcome to This Explainer. Okay, so today we are diving into a truly fascinating piece of legal history that asks a pretty fundamental question. Who actually gets to control the pint of beer in your hand? We're jumping back to 1999, looking at a landmark constitutional court case in South Africa regarding the liquor bill. And I promise you, this isn't just some dry story about alcohol regulations. It's this gripping tale of a newly formed democracy trying to erase a really dark past, while simultaneously figuring out how to share power between a massive national government and its regional provinces. It's a classic constitutional showdown, and we're going to break the whole thing down together.
Here is our docket for today. We are going to cover the President's Dilemma, a history of control, the three-tier solution, the epic tug-of-war between national and provincial power, and finally, the final verdict.
All right, let's jump right into part one. The President's Dilemma and a major constitutional roadblock. So, picture this. It is 1999. The South African Parliament has just passed a major piece of legislation, the Liquor Bill of 1998. It has gone through all the usual legislative hopes, and it lands right on the desk of the president to be signed into law. But he pauses. He actually refuses to sign it, which raises the question, what happens when a president refuses to sign their own government's bill? It's a massive, high-stakes moment. Now, the president wasn't rejecting the policy goals of his government. He agreed with those, but rather, he had deep, fundamental reservations about whether the bill was actually constitutional.
Well, to answer what happens next, we have to look at Section 79 of the Constitution. You see, the 1996 South African Constitution built in this absolutely fascinating set of checks and balances. The president doesn't just have a simple blanket veto power. If he has constitutional reservations, he's required to send the bill back to the National Assembly. And if they don't accommodate his concerns, which, spoiler alert, they didn't in this case, he can refer it directly to the Constitutional Court for a final decision. What's wild is that this was the very first time this referral power was ever used. So before this bill even became law, the supreme authority of the Constitution was put to the ultimate test.
Which brings us to Part 2, a history of control and the legacy of apartheid liquor laws.
Now, to really understand why the national government was so eager to overhaul the liquor industry in the first place, we have to look back at the dark legacy of apartheid. For decades, liquor was aggressively weaponized. It was literally an instrument of racist social control. The acts passed in 1923 and 1928 basically prohibited the supply, delivery, or possession of liquor by black South Africans, and the enforcement of this, it was brutal. By 1957, a staggering 16.8%, that's nearly 1 in 6, of all convictions of Africans were for statutory liquor offenses. We're talking about people getting a criminal record just for possessing a drink.
And honestly, the system was completely unworkable. By 1960, even the apartheid government's own Milan Commission basically threw their hands up, officially calling the application of the Liquor Act a question of impossibility. People were obviously still buying alcohol, right? But the incredibly strict racial regulations had just pushed the entire industry underground into this chaotic, illegal market.
So, by the time the new Democratic government drafted the 1998 liquor bill, they weren't just tinkering with some standard business regulations. They were fundamentally trying to dismantle a deeply shameful history of oppression. Under the old laws, black citizens faced constant police harassment and were legally restricted to brewing only umkombothi, or sorghum beer. Otherwise, they were forced into illicit trades, paying extortionate prices for dangerous, adulterated alcohol. The new government desperately needed to open up this market to historically disadvantaged groups and break apart the massive monopolies that had thrived under white minority rule. All right, let's move on to part 3, the three-tier solution and restructuring the industry.
So what was the government's fix? They decided to legally slice the entire liquor industry into 3 distinct, highly regulated buckets. First, manufacturing. That's the actual production or brewing of the alcohol. Second, distribution, meaning the wholesale transport and the storage depots. And third, retail, the local bars, taverns, and bottle stores selling directly to you, the consumer.
But here is where the bill really showed its teeth, the anti-monopoly rule. Basically, you could only register for one, and literally only one, of these 3 categories. The government's goal was to strictly prohibit massive corporations from owning the brewery and the delivery trucks and the local bar all at once. By preventing this kind of vertical integration, they hope to crack the doors open for new, smaller entrepreneurs, especially those who were previously disadvantaged, to finally get a fair piece of the pie.
Moving right along to Part 4, National versus Provincial Power, the ultimate constitutional tug-of-war.
This is where the real legal drama begins. The South African Constitution, by design, divides power. Under Schedule 4, the national government has authority over broad macroeconomic things like trade and industrial promotion. But if you flip to Schedule 5, the provinces are given exclusive absolute power over liquor licenses. So you see the collision course here, right? The National Minister of Trade argued his bill was all about regulating national trade and busting monopolies. But the Western Cape provincial government fired back, arguing that the bill's registration system was, in reality, just a massive liquor licensing scheme, something that belonged exclusively to them.
However, the Constitution does have a built-in failsafe. Enter Section 44(2). This clause allows the national parliament to override the provinces and step into their exclusive territory. But, and this is a massive but, only if they can prove it is strictly necessary to maintain economic unity or essential national standards. Not just helpful, not just a good idea, but absolutely necessary.
So the battle lines are drawn at the Constitutional Court. On one hand, you've got the minister arguing that without a unified national rulebook, you'd have total chaos. Think about it, a massive national brewery trying to navigate 9 completely different sets of provincial rules for manufacturing and shipping, it would totally fragment the national economy. But on the other side, the province argued that this bill gobbled up all their real licensing power. It essentially reduced them to mere administrative puppets, told exactly what to do by the national government, which totally violates the spirit of provincial autonomy that the Constitution was supposed to guarantee.
And that leads us to our final section, Part 5, the final verdict, splitting the baby. The court delivered this incredibly masterful, nuanced verdict that essentially split the baby down the middle. They ruled that the national government could control manufacturing and distribution. Why? Well, because brewing and wholesale transport are large-scale cross-border industries. The national government successfully proved it was absolutely necessary to override the provinces here to maintain economic unity. So that part of the bill, totally constitutional. But when it came to retail sales, the local taverns and liquor stores, the court ruled this was unconstitutional overreach.
To get to that ruling, the court really had to pin down what economic unity actually means. Justice Cameron made this brilliant point. The Constitution creates a single sovereign state with a single economy. For massive operations that ship products across the entire country, you need oneness. You have to have a single national rulebook to avoid fragmenting interprovincial trade.
But when you zoom in on the retail side, the local pub or bottle store, that logic just falls apart. Retail sales are inherently local. They're intra-provincial. The national government completely failed to prove that they needed to strip provinces of their retail licensing powers just to hit their big-picture economic goals. The court decided that local communities and provincial governments are hands down in the best position to understand their own neighborhoods, handle local retail licenses, and manage the social impacts of alcohol on their own streets. Because of this fatal overreach into retail, the entire bill, as it was written, was declared unconstitutional and sent straight back to the drawing board.
This whole case, it was a monumental stress test for a brand new democracy, and it proved that these constitutional checks and balances actually worked. The president did his job by raising the red flag, the court did its job by interpreting the law impartially, and power was meticulously balanced. It leaves us with a pretty vital question to ponder. As we navigate the complexities of any democracy today, how do we continue to balance the need for national economic unity with the essential everyday autonomy of local governments? It's a constant tightrope walk between national efficiency and local freedom. Thanks for hanging out with me on this explainer, and keep asking the big questions.